Hello, everyone, and welcome to the Labour Justice Barometer podcast. I'm Aisha Adam.
And I'm Debbie Collier.
And we're your hosts today on the Labour Justice Barometer. In the first part of our special two-part episode, we return to a key theme from earlier in the season, employment equity and affirmative action. Now, throughout our episodes, we've unpacked several developments in this space, including the Employment Equity Amendment Act, the introduction of sectoral targets, and the broader policy and legal frameworks shaping transformation in the workplace. Now, in light of the recent Democratic Alliance case, which challenges the constitutionality of the EEA amendments, arguing that while transformation is necessary, the new targets may undermine fairness for all, questions about the purpose, design, and impact of affirmative action are once again in the spotlight. The state, for its part, maintained that these tools are lawful and necessary to accelerate workplace equity. So to help us make sense of these debates, we're joined by Professor Andre Louw from Stellenbosch University. He teaches labor law in the Department of Mercantile Law and has published widely, both locally and internationally, on employment law, affirmative action, and other labor law issues. With his critical lens and extensive writing in this area, Professor Louw brings a sharp perspective into how the law is evolving and where it might be heading. Welcome back to another episode of the Labour Justice Barometer, and today we're returning to one of the big themes from earlier in the season, employment equity and affirmative action. And if any of our listeners have been following us carefully, we actually discussed the EEA at the start of the year in episode 4, which actually really set the stage for significant developments that we're actually seeing now, particularly sector targets, regulations. And in episode 13, we actually covered a proposed labor law reforms episode overview where we looked at the LRA, the BCA, and we briefly touched on the EEA developments there and promised that we'd come back into more detail. And this is that episode today. So Debbie and I are really pleased to be joined today by Prof. Andre Louw, who brings a really strong perspective on this area of law, and he is a strong scholar in this area of law, especially about the current debates on affirmative action and how this is unfolding within South Africa. So, Andre, welcome, and thank you for joining Debbie and I.
Andre, it's great to welcome you on the show. Thank you so much for joining us to the conversation today.
Thank you very much, guys. It's a privilege to be here, and I've been following a few of your podcasts, and I really think it's a great benefit, I think, for scholars, practitioners, students, everyone. So please keep up the good work.
We really appreciate that, Andre, and that's exactly why we have you here today, to build on that engagement. So let's dive right in. You've been known to take issues with aspects of employment equity law and the framework for affirmative action. And you've raised concerns about affirmative action, particularly in specific contexts, including the public sector. Can you just tell us what are your main criticisms and what have they been over the years? And how would you categorize this?
My personal view has always been that I think the most fundamental aspect, of affirmative action under the Act, the EEA, has never really received the required, what I think the judicial scrutiny it should have received long ago. And it actually also hasn't been pertinently challenged before the courts as such by these serial litigants like Solidarity, AfriForum, etc. What we've seen over the last couple of decades have been really legal challenges over that old chestnut of whether affirmative action measures under the Act constitute targets, legitimate targets, or are they, illegitimate or unconstitutional quotas. Now, that question specifically, I think, we only faced that because the EEA introduced this, what I like to call this numbers game, into our equality law. But I think there's something much more fundamental here behind that. And that, for me, is a simple question. What the heck does representativity, and especially demographic representativity, have to do with equality? So we know that the EEA works with this idea, or is it an ideal, that once our workplaces are demographically representative, then we would have achieved equality. And this is central to how Chapter 3 of the Act, the affirmative action chapter, actually works. I think it's important to note that it doesn't use the concept of representativity. It talks about equitable representation. And then the Act, of course, introduces this concept of bringing demographic representativity in terms of the population statistics into workplaces. It doesn't use that as a benchmark, right? Where in class, I sometimes use the example with students saying that if you have a workforce of 100 people and 80% of them are white male, I think using population statistics as a kind of a barometer is helpful as a benchmark to say that, listen, there must be something wrong here. There must be barriers, or there must be, overt or covert unfair discrimination happening here. So there I can see a logical connection, between representativity and equality. But the Act doesn't do that. It actually sets up representativity and then ultimately demographic representativity as the objective of affirmative action. And I'll just remind you guys, Section 2B of the Act, which is, I think it's central, it talks about what the purpose of the Act is, says specifically in respect of affirmative action that the objective is to redress disadvantage due to past unfair discrimination. That's great. That's what we see in Section 9.2 of the Bill of Rights. But then it continues to say, in order to ensure the equitable representation of designated groups. So it doesn't define equitable representation. Section 42 then, of course, works with demographics, and that's how this whole thing came into our equality law, and especially demographics then came into the lexicon. So that for me is, okay, this is where and how and when we saw representativity introduced into our equality law. But where did it come from? And there, of course, the proponents of the Employment Equity Act scheme, including, of course, Department of Employment and Labour, the Employment Equity Commission, will always tell us that it comes from the Constitution. But we all three know that if you go to the Constitution, you only find a very, very limited introduction or reference really to representativity in respect of certain institutions of the state, right? And it says that these institutions must be broadly representative of our people. So now we're looking at its application to Chapter 9 institutions, the Public Protector, the Human Rights Commission, the judiciary, and the public administration. Now, there are two things to note about that. The first one is that the Act, and I believe our highest court or some judges there, have taken a very big leap from this concept of what is broadly representative to exact demographic representation in line with population statistics. And that's what the EEA does and has been doing for nearly 30 years. And now the Employment Equity Amendment Act, which I like to call the EEA on steroids, requires this. So it makes this big leap. Former Chief Justice Zondo tried to make this argument in the Correctional Services judgment in the Constitutional Court in 2016. You'll be familiar with that. Taking this leap, as I call it, from broadly representative to exact demographic representation. In one place in his majority judgment, he states actually that if any group, including white males, are underrepresented in the workplace, measures should be taken to ensure their representation in line with demographics. Now, we know that, of course, is completely anathema to what affirmative action is. Even Section 9.2 in the Constitution, which permits the use of affirmative action, requires it to be measures in order to redress past unfair discrimination against the group that's targeted, which, of course, we know physically white males simply do not qualify for. Now, that's the first problem. The second problem is that the Constitution, of course, says nothing about representativity in respect of private sector workplaces, where, of course, we've seen, hopefully we'll talk later about the public sector, but we've seen very, very significant application of affirmative action under the Act in the private sector. So I think it's time for us to acknowledge, and I don't know if I'll become controversial here, this numbers game of this Act specifically is not something the Constitution requires. It's not something it sanctions, I believe. I think it's a very ambitious and a wide-ranging form of social engineering, which, and now will be controversial, has long roots in the National Democratic Revolution. Now, that's a fact. It's not a political statement. Any of the listeners can go and Google this. They can go and look for these references to representativity in the NDR documents of the ruling, the African National Congress since, I think, the 1960s. So I believe this is simply a form of social engineering. But the problem for me, it goes beyond that, because I think when we consider demographic representativity, specifically within this equality paradigm, it's replete with irrationality. There's so much irrationality there for me. The first point there is that you can only logically, I believe, defend demographic representativity in a workplace, in a workforce, if you can show that hadn't it been for past unfair discrimination, let's say we came from this discrimination-free utopian past, which of course we don't, but let's say we did. You can only logically defend demographics being relevant in the equality context if you can show that hadn't it been for past unfair discrimination, our workplaces would, as a matter of course, would have been demographically representative. And I challenge anyone to prove that. I don't think you can prove that ever. I'm a big follower of that prominent U.S. economist, Professor Thomas Sowell. I believe he's 95 this year. He's still writing, bless his soul. He's researched this thing over the years, specifically, and found that nowhere in the world has it ever happened that industries or sectors are demographically representative of populations. If you do find it in certain outlier cases, it's because it was specifically engineered to be so. And that is what I believe the Employment Equity Act in Chapter 3 has set out to do, and it has been doing for nearly 30 years. So just a quick question then. Can we say that had it not been for past unfair discrimination, would 80% of our airline pilots, for example, have been Black African, 7% of them white, 5% colored, etc., down the line? Right? You can't make that rational and logical connection there. There are too many factors that influence what people do. We all have different interests, attributes, characteristics. I have two older brothers who are both engineers. My maths was simply not there, so I went into law. All of these things, mentors, role models we've had from an early age, this whole life lottery thing determines why people are in certain careers, etc., amongst a vast array of factors. But what we find in the EEA is now attempts to engineer racial and gender representation to some decimal point. We now have, under the Amendment Act, in workplaces across 18 sectors of the economy, with the minister given the power to decide this, externally impose numerical targets on designated employers. And I just think this is Orwellian. It really is. If I can end that point just on really being controversial, I've said this in some master's classes in the past. that this kind of social engineering has been tried elsewhere in the past in a limited number of cases. And one notable example for me was in the 1930s in Germany, where the Nazis defended the kicking out of Jews from certain professions, medical profession, banking, insurance, those kind of things, because they were claimed to be demographically overrepresented in those fields. And we all know how that ended. So I'm not a fan of that. Finally, on this, just having talked about what I believe to be the irrationality of demographic representativity in the equality context, I just like to touch on the morality. And here it's nice to speak to labor lawyers like yourselves, experts, because we all three are very familiar with a case from a decade ago, Naidu versus Ministry of Safety and Security. Indian female officer in SAPS denied promotion in Gauteng based on the fact that if they promoted her, Indian females would, according to the equity plan, have been overrepresented at that occupational level. Now, I'll just remind the two of you, because I often use this example in class, so it's kind of in back of mind, that the target that the SAPS equity plan set there for Indian females was calculated to be 0.037 positions that could be allocated to Indian females at that level, which then was rounded off to zero, of course. And SAPS then said they viewed the representation of Indian females at that post level to be ideal because the target was zero and there were no Indian females at that level. And I just question, how morally just is that? And how can it be constitutional? Section 9.2, the source of constitutionally compliant affirmative action, of course, remember, starts off by declaring in its first sentence that equality includes the full and equal enjoyment of all rights and freedoms. And I just would say, go and try to sell that idea to Ms. Naidu, someone who, being Indian, being a female, was doubly disadvantaged by past unfair discrimination. And now she's denied promotion based on affirmative action because her race group is what I would say numerically challenged in the population statistics.
You've raised the social engineering aspect of this, but I also get a sense from your discussion that your problem lies with the degree of specificity in the demographic representativity and, the problem with decimal points, because that is troubling. But am I understanding from you that some level of social engineering would, if you have the workplace again with 80% white males, whatever it might be as you laid out, you're not suggesting that social engineering in that context would be inappropriate. It's the form, it's the measure, it's the design. Or am I understanding you incorrectly? So the demographic representativity, how we're interpreting the Employment Equity Act against the constitutional imperatives, representativity, broad representativity is an aspect of equality, but it's not the whole picture. But yeah, maybe just a view on how do you achieve broadly representative without social engineering in the context that we find ourselves in? Do you see a place for social engineering, just a better design, a less decimal point articulated measure?
Good question. Definitely, I believe a spectrum has gone too far. There should be a spectrum. Of course, being a lawyer, I don't want to get pedantic on the point, but of course, you mentioned again now broadly representative. I would just say again that of course there's no constitutional requirement, or I would suggest sanction for that in the private sector specifically. But no, I definitely agree. I'm anticipating that at some point you're going to ask me, what do I think we should be doing? And I've thought about this, and I think I really would align myself with something that the South African Human Rights Commission, in I think it was their 2017-2018 annual report, they had a chapter on equality. And of course, this was as part of their reporting function to the Committee on the Eradication of Race Discrimination in the UN. So as part of that function, they have this annual report. And in that report, they found or suggested that the current EEA system, what I've been talking about, this demographic representativity in respect of population statistics, is unconstitutional. And I completely am aligned with that position. And they made the suggestion, which I also would align with, that it would be a preferable criterion not to go on these blunt racial population statistics of the different groups. And we've seen how that has played out in the courts, even how it can have such detrimental effect. I think I mentioned earlier the correctional services case, those coloured employees in the Western Cape, you know the story, who were subjected to an employment equity plan with nationally calculated targets, which of course meant that they were already vastly overrepresented in the Western Cape province, where their population demographic representation is much higher than anywhere else in the country. So the Human Rights Commission suggested that we move away from this blunt approach based on race and gender statistics, and rather go towards using socioeconomic needs and circumstances as the main criteria. So it's that old chestnut of, should Patrice Motsepe's children benefit under the Employment Equity Act's population statistics model, being persons from a designated group who may benefit from an affirmative action model based on population statistics, on demographics, which is a statistic, right? Or should there be a deeper dive and to actually consider socioeconomic circumstances? And I remember you probably know Martin Brassey, very prominent senior counsel and author on labor law. I remember he wrote an article in 1998, I think it was published just after the introduction of the Employment Equity Act. And he was very critical of the Act, of course, for various reasons. And he made a point that I also always try to bear in mind, is that when it comes to appointment decisions in, let's say in the private sector, it goes across the board. But a private, let's say it's an insurance company, you have advertised you want to appoint someone, or you have an existing employee who's up for promotion. The workplace scenario, and that, if I could call it that interview scenario, that recruitment and selection scenario, lends itself very well to making determinations based on actual personal attributes, characteristics, circumstances, history, etc. What the Employment Equity Act does with this, going to certain decimals with population statistics, it is forcing, and now especially from externally from the minister, it is forcing designated employers to use what I like to call this Excel spreadsheet approach. It's a head counting exercise, a complete numbers game. You have to have certain targets which inevitably, I believe, turn into quotas that you have to reach by a certain period of time, and you are not concerned really with the individual applicant for promotion or appointment or whatever the case may be. That scenario, recruitment and selection scenario, allows you to actually do that deep dive. Who are you? Where do you come from? Did you come from poverty? What level of education did your parents have, etc., etc., etc.? Those considerations, I believe, that is what we should be basing affirmative action decisions under the Act. We should be basing it on that. So I do agree that, of course, as in my earlier example, if there is this vast overrepresentation of one specific group, there is a problem. We need to have that the fairness of representativity should play a role. I've always felt that I can't see how fairness cannot play a role in adjudicating the legitimacy, the legality, the constitutionality of affirmative action. If we think in terms of Section 23 in the Bill of Rights, the right to fair labor practices, the application and implementation of an affirmative action policy or a measure is a labor practice. So the beneficiary and the non-beneficiary of such a measure or a policy has a constitutional right to that practice being fair. Our courts have not acknowledged this, I believe, and has stuck to this rationality test that says if a measure is designed to promote equality, it's pretty much, if you call it affirmative action, it passes muster. I don't believe that, for the reasons I've already mentioned in terms of the role of demographics as it is currently under the Act, I believe those elements of irrationality there already shouldn't pass muster under the Van Heerden test. I do believe there must be a reflection of representation of all the different groups, but it should not be this under this imprimatur coming from the minister or the legislature saying exactly how that should look. That is a determination that should be made at the workplace level, in respect of individual engagement between employers and employees or prospective employees, as well as collective representatives, trade unions, etc. I do not believe this is something that should be, in this way, be imposed on employers, and especially not now under the Amendment Act, externally by a minister with a discretion to determine what she or he determines to be equitable representation, but tied to this arithmetic Excel spreadsheet approach.
You're listening to the Labour Justice Barometer, and we'll be right back.
You know, I do think perhaps it's the formula that the minister has available to them. I'm sure if the targets, as they are called, were presented in a different way, I am concerned about leaving decision-making up to individual employers. But, I do agree with, I share reservations about the targets, but perhaps not to the extent that you do. But I want to get back to something else you said. You spoke about the Human Rights Commission report, which spoke, to using socioeconomic circumstances as criteria. And we saw, both in legislation and in terms of politically, that idea really did not progress in a way that might have given more light to that approach, and in some ways, has been overlooked. But it brings me to thoughts around the lawmaking process and also separation of powers. The role of the judiciary and the role of the legislature, and what is politically tenable, and the kind of social and political processes in making law. Because I do think that ties the hands of Parliament, but also Parliament ties the hands of the judiciary. So I think some of these, there's some. It's a complex process. It's clear that there's a high level. I mean, we haven't even mentioned, the challenges that even a party to the government of national unity is bringing to the target. So clearly, it's right now for having the discussion and the types of discussions that we're having. And clearly, there's a high level of dissatisfaction But I do wonder, just reflecting backwards and going back. I mean, you go back to Brassey's views in 1998. Was it? And when we think about law as a social political process, was it really tenable to do other than what we did do? Quite apart from this being a laudable objective, it would have been great if we could have achieved it in ways that were perhaps less imposing on employers and less, unforgiving of drumming down to the decimal point. That's caused a lot of problems in practice. But no laws are ever perfect in their implementation, and objectives and unintended consequences are real and visible in most instances. So there's a lot we can learn from. But I do wonder, going back to the origin of the provisions in the chapter in the EEA, whether there really was, much room to differ from where we are. But I'll stop there. Asha.
I think this is the tricky question around how, just tying around and seeing more closely how socioeconomic disadvantage could better target the policy, or how this can be, how difficult it is to operationalize, and creating space for this, especially with, high unemployment rates and economic growth. And I see that as being a foundation first. And it is an interesting one, though. I think politically it's a very tough conversation to have. And I think if we just dive into one of the questions that I want to ask you, Andre, looking at our EE law and the recent developments within the EE law, what do you see as these major changes, and how would you view these changes? Are they significant? You've given us an idea in terms of affirmative action, but are there any improvements, or is it just all bad, a mixed bag? This is where I would also invite you to talk on the recent DA case.
Debbie, if I could just, sorry, Aisha, before I get to your question, I do agree. Going back, I think when we talk about 1998 and around that time, now we definitely needed something. And I think personally, I'm not averse to affirmative action. I think we need it. I think we're going to need it for quite some time still. It's just the specific form, the formula, if I can call it that the legislature chose. So I completely agree with that. I just think that, if we look back at what we've seen in practice, and I've given some examples like Naidu's case, the correctional services case, of how these things have played out. Now, okay, those were, of course, public sector cases, to be pedantic, but it's the same principles. And I just think that, as you said, Debbie, this, if I can paraphrase, I think if I understood correctly what you're saying, that this thing of the Human Rights Commission, or the suggestion, which of course was also, I think, Solidarity, the trade union, for a number of years have been pushing for that as the main criterion for affirmative action, hasn't found political traction. And for me, it might be an issue of political will. I do not want to talk politics, but we do get back to, as I've said, the demographic representativity. Specifically, demographics have played a central part in the national democratic revolution, or at least the founding documents, etc. So I do not think that there has been a political will in these last 30 years, or let's say at least since we started seeing implementation of the Employment Equity Act and how there have been problems, that there has really been a will to move away from that. And also, in having mentioned the Human Rights Commission report, which ironically for me, I think you might be aware that that report was later, I think, not challenged, but Solidarity went to court, I think, to, if I remember correctly, to have those recommendations of the Commission, to have them, I can't remember, maybe made an order of court to force the Department of Employment and Labour to actually listen to what was suggested and to go back and possibly amend the Act in these respects regarding the use of demographics. And in that case, for me, ironically, the Commission itself actually argued, and the court agreed with it, that that report was only research. Those were not binding recommendations, so there was no compulsion on the government to actually go, or the legislature to go back and revisit the Act. But for me, what talking about the political will, or my impression of it, is what was very interesting, is that the department dragged its feet after that report came out. I think it was about 2 years or more before they came out with the Employment Equity Amendment Bill at that stage, where it completely had ignored what the Commission had suggested and actually had just turned their faces against it, it seemed, and doubled down by, instead of saying, okay, we will consider possibly the problems with these statistics and rigid application of demographic statistics, we will consider maybe moving away from that, not doing that, but actually doubling down and saying, no, we're sticking to that, and we're now going to say it's not Mr. or Ms. Designated Employer, it's not within your sphere of influence or whatever anymore, how you set your numerical targets. We want to let a cabinet minister come in from the outside and tell you what those targets should be.
I want to put another perspective on that political will aspect, and social, because I think it's something bigger than political will, or it's political will, in a very real social context. Because at the time of the fees must fall, roads must fall, the disruptions on campus, which were significant, it was precisely at the time that universities also, at least the university that I was with at the time, was putting on the table, let's move away from race and race demographics to socioeconomic considerations. And that was rejected wholeheartedly. And I won't say that precipitated roads must fall, fees must fall, but it's part of a social context that's much bigger than just, the will of the politicians or the ministers it's really a very much a socially embedded phenomenon, I would argue, which makes it it makes decision-making in the space really quite complex and tricky.
Stay tuned for part 2 of this episode, where we'll continue the conversation with Professor Andre Louw. We'll dive deeper into affirmative action, explore possible future developments, and unpack what could be in store for South Africa's employment equity framework.
This podcast is not intended to constitute legal advice.